But I want us to know that this is not a political case. This is a criminal trial. Now, Sowore, I remember the day I was here, this issue of Sowore calling the president a criminal. And I said clearly, the DSS has the responsibility to reprimand or to ask him to retract whatever he has put in on X social media. And he was given the opportunity to retract. He did not. Now, DSS had decided to take him to court. This matter is before the court of law. As a matter of fact, he subjected himself to decision of the court by taking his plea, one, by allowing the prosecution to call their witnesses. He cross-examined them through his lawyer. As a matter of fact, at the close of the prosecution's case, he raised a no case submission, which the court dismissed. Now, it is his turn to defend himself. So we must divorce politics from what is happening now. Now he has see, you have alleged that you have done this. It means that you have evidence to that effect. So if you are called upon to defend yourself, what's the difficulty in that one? So if any Nigerian can be called upon to defend himself, then Sowore case cannot be exceptional. It was the same court who granted him bail on personal recognition without any choti. That felt, look, you have violated the conditions upon which you were granted bail, that revoked the bail. Now, this court said that, on the 12th of March, 2026, you absented yourself from the court proceeding. On the 16th of June, equally, you absented yourself from court proceeding. This is a violation of your condition, bail condition. Though Sowore wrote a letter on the 16th to say, he was attending to his head, going to hospital. The law is clear. If you have any excuse, you must provide evidence. Now the question you ask yourself is this: did he attach the medical issue or the medical visit from a reputable hospital to show that actually that was his business that day? He did not do that. So the court felt, you are handling this matter with levity. Now, if you have a criminal charge hanging on you, it should take priority over any other thing. So it is based on that the judge, and apart from that, perhaps it is possible that the court has considered his unruly behavior in the court. That's contempt on the face of the court itself.
Is there any part of the Nigerian constitution that actually criminalizes calling a person a criminal, whether it's a regular Nigerian or a politically exposed person or even the president? Is there any aspect of the Nigerian constitution that says
it's under Cyber Crime Act, particularly Section 24? That's why he was charged, not under Constitution.
Right.
You have the criminal, you see, they are part of the sections of the cyber crime that criminalizes some acts. And what he has done falls within one of it. When you call a president of a nation a criminal, it's like cyber bullying.
Really?
And that's why they are, we are not here to debate what is happening in the court. The fact of the case is before the court. Now, why are you running from defending yourself? If truly you have evidence, he has been saying and boasting that he has evidence, he will prove it. Now we have got to that stage of proving it, you can't go away. Now, he has his right. In fact, as he is now, he's presumed innocent.
Until proven guilty.
Until proven guilty. So the prosecution has led evidence. You have cross-examined. You have raised a no case submission. The court has overruled you. Defend yourself. What's the big deal here? If you have evidence, place it before the court and let the court decide one way or the other. But so in the whole scenario, I don't see a place where we can play with DSS.
All right, but
it's only before the court.
However, Sowore supporters and some Nigerians have argued differently to say that the way he was handled by security operatives within the court premises undermines the very dignity of his rights in the first instance, and speaks to intimidation even within that temple of justice.
Okay, let me take you back.
Very quickly, because we have about 2 minutes.
Let me take you back. The same DSS tried Professor Patutomi. The same DSS are being caught against Sarah. DSS against Justice Crack, and they'll be acting civilly. Now, if you misconduct yourself, because when you're in the court, you comport yourself. When you begin to use foul languages on the judge.
Are you in court?
I'm not in court, but it's there. It's in the public domain.
Okay.
So if you begin to do all those things, nobody's above the law.
All right.
Sowore had cooperated much with the court and abided by the rules of the court, appeared on all the days he was supposed to appear, but his appearance in that court was pervaded with hostility, in the sense that the court, first of all, had the premonition that Sowore was recording proceedings using some of his gadgets, and so he was asked in the course of proceeding on several occasions to remove his glasses, to remove his wristwatch, and all form of directives from the court. And he felt that that was dehumanizing. And then we continued to manage the situation until the proceeding got to a point where one of the lawyers in the team was even asked to come and kneel down by the judge. And that kind of sanction does not exist within any of the laws.
Well, that sounds extraordinary.
Within any of the laws that we have.
Now, the court's position, and correct me if I'm wrong, is that Mr. Sowore failed to appear at a scheduled hearing leading to a bench warrant. Why shouldn't this simply be seen as the ordinary consequence of failing to comply with a court order?
Well, there are several reasons, but I'll just limit it to as few as possible. The fact of the incidents and circumstance surrounding the revocation of Sowore's bail is that on the 15th, the matter was slated for ruling of an application that had been previously heard. And so on the 15th, Sowore appeared in court, but the court did not sit. But there had not been a prior notice that the court would not be sitting. And so Sowore left and made an application for an adjournment on certain days, knowing that he would not be around for a while. He made an application, and contrary to what the SAN said on your program, that Omoyele Sowore said that the grounds of his application for an adjournment was on ill health, that's the lie. In that application did not state any grounds. It just simply stated that I wouldn't be around for a while, but I'm suggesting some dates subject to the convenience of the court. And so the court resumed on the 16th without a hearing notice to Omoyele Sowore, and the law is trite that a party who failed to attend a court proceeding cannot be penalized if he had not been served with a hearing notice. In any case, the matter was coming up for a ruling, and by section 266 of the Administration of Criminal Justice Act, a criminal proceeding can take place in the absence of a defendant if the matter is coming up for the hearing and determination of an interlocutory application. And that day, the matter was adjourned for the ruling of an interlocutory application. So the absence of Sowore on that said day could not in any way scuttle proceedings. And so we find it a bit absurd that, and then the procedure, if a defendant is absent, is to invite the sureties, because part of the conditions for his bail is that there were people who took him on bail. And so it's to invite those people to produce the defendant and then give the defendant an opportunity. The fair hearing we're complaining about, the defendant must be afforded opportunity to tell the court why he was absent, and to tell the court why his bail should not be revoked as a result of his absence. None of that was done, and it forms part of the grounds that Omoyele Sowore feels that he might not get justice in that court. I saw him today and he repeated the same thing.
At the heart of this case is Mr. Sowore's description of President Tinubu as a criminal. Is your argument that such language is protected political speech, no matter how offensive or controversial it may be?
Well, unfortunately, at this point, I may not be able to delve into the justification of the statement because that matter is sub judice and that is for the court to determine. But what I can say as per this is that the oxygen of democracy is criticism. And democracy is tested not with the popularity of the government, but it is when the unpopular voices are, when the government of the day has the tolerance to accommodate unpopular voices or voices that are dissent, are critical to its policies and its operations, then we can say we have a true democracy.
Yeah, but the government will argue that every single day, and I would certainly to some extent agree with them, that people sit where you're sitting and criticize the government, and they don't get arrested. So if a citizen publicly accuses a president of criminality without a court conviction, why shouldn't that attract legal consequences?
Well, first of all, it would be very limiting to determine the language that any Nigerian chooses to use in criticizing the government.
Well, I mean, if you call somebody a criminal,
yes,
that's more than just saying that he's not doing what he
was consequent upon a statement which he believed
elected to do.
It was consequent upon a statement that the president made that Sowore called him a criminal. And when Sowore was investigated, he said, I can defend the statement I made. And we are before the court, and we are saying he should be afforded the convenience to defend himself. But I have another rationale as to why, your question as to why other Nigerians can criticize and they are not being prosecuted or persecuted. Why Omoyele Sowore? The reason is simple. He's a presidential candidate. No matter how strongly the language Omoyele Sowore has used, there are justifications for his use of that language. Number one, President Tinubu is Omoyele Sowore's opponent, is his political opponent. You could recall the President Tinubu had made certain extreme statements against people like Atiku, people like Peter Obi in the past. And so he cannot, because he's the president now, utilize the state institutions to prosecute someone who makes similar statements against him.